Welcome to Think Smart with TMFG. I'm Mike Connon. This is John Iaconetti, financial advisor with the McClelland Financial Group of Assante Capital Management. So, John, today we read some stats on things, and one was talking about estate planning and wills.
Yeah.
You know, there's 60, when you look at people over 55, what would you expect? You know, if you're over 55, do you think you would have a will?
You'd expect close to 100% of Canadians to have a will, at least in terms of our industry. It's the number one thing that we think about, but I think the average Canadian doesn't quite necessarily think about it. And the stats have come out.
Yeah.
It's about 64% of those above the age of 55 have a will, which was, I thought, a bit staggering.
So that's 36%. So 1 out of 3 people you meet on the street that's over 55 years old does not have a will.
Yeah.
Which is staggering. And I mean, that's a conversation we have to have with people, number one, just to make sure they're online with that. And the other thing we went through is this this one piece that was written, and it talked a bit about, it gave 5 major points that you should make sure in your estate planning.
Yeah.
So we'll go through a few of them and see which ones really stand out.
Yeah.
I guess the first one was number 1, make a will.
It's pretty straightforward.
Pretty straightforward. So just to let everyone know, there's an order of operation in different provinces that tell how your will be distributed.
Yep.
If you die. It's what we call dying intestate.
Yep.
And if you die intestate, it means you die without a will. And there's a breakdown of where your assets go. If you're married, they'll go to husbands and husbands to wives and wives to husbands. If there's no spouse, it goes to kids. It will follow an order there. If you don't have kids, it can go between siblings and parents.
Yep.
So it has a bit of a distribution, but this is already set by the government.
Yep.
So if you don't want the government's distribution of your estate, number 1 is get a will.
Absolutely. And you know, for some people, you know, maybe you're listening and you think, okay, well, if I don't have a will, you know, I want it to go all to my spouse anyways, or what have you. But there's a lot of situations where, you know, family dynamics change. There could be divorces. There could be kids that become estranged, and maybe you don't want them to receive the money, or maybe issues with them being able to handle the money. You know, the government doesn't care. They'll distribute it. You know, you care. You know your situation, so may as well plan for it.
And a couple other things in there. Well, number 2 to remember inside of that is if you don't have a will, there is no executor of the will. That means people have to actually apply to be the executor of your will. And if there's no one who wants to take on that burden, or if there is not enough in the state to make it worth someone's effort, the government can appoint I guess it's a trustee would be involved in doing this.
Yeah.
And that gets very pricey and very expensive. So probably not the ideal way to go.
Yeah. No one's just going to come out of the woodwork and be excited to be your executor.
Yeah.
That's not going to happen.
Particularly if they're not one of the beneficiaries on it. So that's with wills. I guess the second thing people do is some people try to do wills themselves. And I know with ChatGPT and stuff, it's you can do pretty good jobs on some of this stuff, but the problem is it will just give you the information that you're entering into it, and people don't know how the laws work. I mean, you talked about spouses before. You can't just cut your spouse out of a will, right? So people tend to do that and make a will that doesn't have their spouse involved. It doesn't work like that. When the government gets a hold of that, there may be some obligations that are required to be paid out before that will. So some people create wills that aren't really valid.
Yeah, absolutely. And I mean, one of the big mistakes that people can run into when they're not having a will, I know we already talked about obviously letting the government dictate where things go, but if things are ambiguous and there's not correct set of details, a big part of that is families fighting over the estate. And it becomes a bit messy. I mean, the biggest issue tends to be, I think, cottages. You know, when you have multiple kids trying to fight over a certain asset or determining, you know, what percentage is theirs. When you don't have a set amount of rules laid out in a will, that's when it can cause a lot of issues and leave your money left in limbo.
Yeah, I guess that was their second point, is ambiguity in a will.
Absolutely.
And you don't have to let your kids know what's in your will. It's not required. Your will is confidential things. You don't have to let anyone know. But I find some of the best estates that I've dealt with, the parents were very open beforehand about how the will works and how it was set up and why it was set up that way. And it might not be an easy conversation to have. And what happens, a lot of people don't want to have, you know, they write things in a will because it's secret, and they figure, well, I won't have to deal with it. And they think, you know, it's relieved that pressure off them having to deal with, let's say you had one child that had less just because there was something went on. And they just say, oh, I'm going to write in the will, that way I don't have to address this situation. The problem is it destroys the family.
Yeah.
From you've built all your life to build this strong family that you've put together. By one small change in a will, you can destroy the entire future of your family right now and for generations to go.
Yeah, no, that's absolutely it. And it's, for us, it feels like a simple conversation because we've gone through it, but it's a very difficult one. And we've tried to implement a lot of these discussions into our practice just by conducting family meetings and just getting, the kids on board with what's going on with mom and dad, what's going to happen when the time comes and they pass away, how the assets get distributed, who plays what role. The more that's on the table, the less ambiguity there is, and the more seamless I think the estate transfer goes.
And usually, even within those will documents, I've heard a lot of lawyers in the past talk about if you're going to go and make something that's an unequal division, put reasons why. And what it does is, particularly if someone cuts a child out of will, if someone has 5 children and puts 4 in it because they want to cut out one, they don't explain it. The one child can come back and say, that was just a misprint. They forgot to put me in it. So a lot of people will put it in and put a dollar value into that just to know that this was done on purpose. Or some people actually put explanations. This is to equalize money I gave, at some point, just so there's some type of understanding of why it's done.
Yeah, absolutely. That's a great point. I mean, the more that's out on the table, the more that's actually documented and less ambiguity, obviously the better the situation would be. That brings us into the next mistake that comes with not having a will or not thinking about your estate planning. And it happens pretty frequently for a lot of our clients and people that maybe have not thought about this ahead of time, but just dealing with frozen accounts and having to deal with probate delays. The less beneficiaries you have or the less planning you do in advance can really put a time delay on the estate transfer.
The ideal estate will be what we call a liquid estate. And a liquid estate is all in financial assets. Financial assets are much more easy to deal with on a estate purpose than real assets. Real assets become very difficult because there's taxes. Sometimes if they're not a principal residence, there's tax concerns. And with those tax concerns, you need appraisals, things like that to find the tax values for the estate. And the other thing about them is they're when we say non-liquid, that's what we mean. They're non-liquid. Yeah. So we have many situations where someone has a cottage, the family bought back in the 1950s. They paid $30,000 for it. It got crystallized in 1994 for $120,000, something like that. And now it's worth $1.5 million. It's a big tax liability that comes with that. So there might be $250,000 or $300,000 tax liability that they're going to have to deal with. And the problem with the cottage is everyone wants a cottage, but it doesn't pay the tax bill. Right? It's not like you can say to the government, you can have 20% of my cottage to take care of your tax bill. They don't want that. They want cash. So in those situations, make sure that's thought about. Some families have put insurance policy in place. And that's a good way to cover that tax bill where we have money aside that's going to take care of that. So there's a lot of different ways to create a sinking fund is another way, just to make sure there's the cash reserves to take care of that. Otherwise, there's a forced sale, and right now we're in a situation where I see a lot of people trying to sell properties, cottages. It's a slow market right now.
Exactly.
Probably 1 out of every 2 clients that has a cottage in Florida are trying to sell it. No luck. It's a soft market. So remember, non-liquid assets are non-liquid. You might assume you can sell them very easily. It might not be the case.
Exactly. You don't want to have the market dictate, what value you're going to get for the family home or really put yourself into a bind. So, that insurance policy, listing beneficiaries, having things liquid and available just eases kind of the concerns when that time does come to actually sell and move forward. So we always stress beneficiary designations, either successor annuitant for spouses or beneficiary designations for kids, just to get ease of access. Because realistically, from our perspective, that money can be distributed pretty well within a week of providing the death certificate. So that's easy access to some funds to help you pay the estate tax and all that, like you mentioned there, Mike. But that leads us into the next mistake, or the 4th biggest mistake that people make when not listing or having a will, or even having someone who's unprepared to be executor. That's going to be absolutely a complete detriment to the estate transfer because it's a very daunting task.
And it's one of the most common mistakes we see. And sometimes I'll say mistake is some things make sense at the time you're doing them. Number one, parents executors, that's a common thing when people are young. but unfortunately your parents get older quicker than you do.
Yeah.
So the idea of them taking care of your estate, being an executor on an estate is a lot of work.
Oh, yeah.
And you really don't want someone in their 80s that's retired, out of the workforce, hasn't been doing this stuff, to have to go taking care of an executor role. It's very difficult on them. And to be honest, it adds, like I'm watching some clients in this situation, the stress it adds to their life is insane. And the funny thing is, of course, there's going to be fees for executors. The people that are in their 80s don't need the fees. They don't want the money. They don't need that. But they have this extra stress that's been put into them of their retirement, which isn't a fair thing to do to someone.
Mm-hmm. No, absolutely. It's, to your point, you want that someone who's going to be trustworthy and someone who's going to be able to step up to the occasion. And oftentimes those two people aren't the same, right? So you really have to be prepared to, if you have created it, even reassess and go back and take a look at it, because things change and that could really cause a lot of stress to the person that you're listing there.
Yeah, and hopefully they're a bit younger than you, and that gives
ideally. Yeah.
Usually, there's a tough situation between when a lot of times when people are in their in their 20s, they can do sisters and brothers and things. But there was that stage before your kids get to the age. I always say usually you want to wait till your kids are at least 25 before you put that onto them. But sometimes those stages, as the kids are coming up to that, where you need someone that your parents are getting older and your kids aren't of the age yet, you have to find the right people.
Yeah.
And remember, being an executor is pick the friend you hate the most and make them your executor, because it's not people always want to say, "Wow, it's so nice they made me an executor." If you have 2 or 3 kids, the one that you don't like, make them the executor of the will.
It's always an honor until they have to act on it, and then they're like cursing your name. So, but that actually leads us into the 5th biggest mistake, or one of the penultimate one, is the overlooking the power of attorney and really planning for potential incapacity for a lot of our clients. And it's crazy to think now, but it's becoming a pretty well common part of late stages of life, not being able to act on your own behalf and having to list someone there, again, trustworthy and able to be able to act on your behalf, and at least having that prepared and set up.
And what people don't realize many times is a will and a power of attorney are never in place at the same time for a second.
Yeah.
So what we go is, while someone's still alive, it's all about the power of attorney. The will has no effect. It hasn't come into place yet. As soon as they pass away, that power of attorney ends, and it goes on to the executor, takes over the role of being in charge of things. So there is an instant changeover, but they're never enacted at the same time. And people get a little bit confused in that, because generally when you go to your lawyer, you do the 2 documents at the same time, but they are very different documents, and they don't necessarily have to be the same people. We see many people with one person as executor, one person take care of the power of attorney for property and finances, and sometimes there's even other power of attorney for health. That's a different person they think should make their health decisions in the future. So that's all stuff to take a look at.
Absolutely. And it's, having conversations with clients, oftentimes people think, maybe some people in this study were, if they're 55, they think, oh, I'm not going to have to worry about that until I'm in my mid to late 80s. Unfortunately, we've had experiences with some people now that late 60s, early 70s, that they're having to have these power of attorneys enacted, due to some issues. Anything can happen, so may as well have it set up and in place just in case.
And another thing for people to remember is you can only make a will when you're in full capacity. So some people try to put this stuff off. If there's any capacity issue, which means you have trouble making decisions or anything like that, you can no longer write a will. And so these are mistakes that if you don't take care of when you're healthy, you can't fix later on. We always tell people, as a power of attorney, there's 2 things you cannot do. One is you cannot name beneficiaries on a will or change a will. Number 2 is you cannot change beneficiaries on any type of financial accounts. So when you get into this whole situation of the power of attorney, they have some control, but there's certain things that have to be the right way before you go into that situation. And wills and beneficiary designations are those things.
That's exactly right. Like you said, you can't go back and fix past mistakes, so it's better to act on it now, and rightfully so. Essentially, the government puts in these rules for power of attorneys not to change those, to protect those that, whose money it is. Obviously, having a power of attorney have too much power can put that person at risk as well. So, these must be reasons why you do create a will. So if you are listening to this podcast, you're over the age of 55 and you've got to get your will created, what are you waiting for?
I hope most people listening have them created, but for those of you who don't, you have some homework ahead of you, and you should do it sooner than later.
Yeah.
Well, that brings us to the end of another episode of Think Smart with TMFG. Thank you very much for listening.